read these words very carefully because this is legislation. This is black letter LAW law. So the Director General is satisfied that the activities or the continued engagement in the activities, now this is the key part, would or are likely to increase the risk of politically motivated violence or the promotion of communal violence. All that means is you're a part of a group that could, because of your views, get other people excited.
Yes.
And then they are the ones that are committing violence.
Yes.
But
you are the prohibited hate group.
Yeah, you're the prohibited hate group because in the absence of your existence, they wouldn't have been provoked.
Yes.
So it's victim blaming.
Yes.
All right, so what I wanted to do today is with myself and my colleague Morgan to talk you through the hate crime and anti-hate group legislation that was passed a couple of weeks ago by Parliament. So we've done a fair bit of work on this. But what I wanted to do is to actually draw your attention and talk you through the specific pieces of legislation and the components of it that go to how a hate group is defined, how a hate crime is defined, the problems, you hear about safeguards and so forth. So I want to talk you through this because one thing that we've heard from a lot of people is basically is disbelief at how bad this actually is. But when you look at the legislation, it's actually worse than what you think. So we'll talk you through this. Hopefully this clears up any questions that you might have about the contents of the legislation. So here it is. Combating Anti-Semitism, Hate and Extremism, Criminal and Migration Laws Bill 2026, which was passed by Parliament a couple of weeks ago. So you may have heard this referred to as the hate speech laws or the hate crime laws or the hate group laws. So what I want to do is to start with what is called the objects of the legislation, which is also objects or what would you say, preamble of the legislation. Yeah. So you can see here in the legislation, the objects of this part, so this is part 5.3b in relation to, as you can see, prohibited hate groups. So what's the objectives of having this legislation as it pertains to prohibiting so-called hate groups? Well, it is to, we are told right here, you can see the highlighted part, first sentence, protect the Australian community or part of the Australian community against social, economic, psychological and physical harm. Social, economic, psychological and physical harm. Now, no one would disagree with physical harm. I seem to recall that it's already unlawful to hurt people physically, rightly so.
In many different pieces of law, it is unlawful to advocate or commit acts of violence.
Right, so we've dealt with that.
So that's dealt with.
Let's go to these three, social, economic and psychological. Now, that could mean what? Anything, couldn't it?
I mean, it's very subjective. What is a social harm? An economic harm? I mean, this
losing your job is economic harm.
Well, this is right. The price is going up. I don't know.
Inflation.
Yeah,
Jim Chalmers is in trouble.
So well, that's right. So these are really ambiguous ideas, and it really opens the door to a lot of dangerous treatment by the courts. So the important thing to remember in an objects clause such as this is that, in particular when you're dealing with legislation that might be highly contested, such as this, is that an objects clause will provide guidance to a judge for how to interpret any ambiguities or contested interpretations within the rest of the Act. So by including these very broad and sweeping objects, it will flow through and be read into the rest of the Act. So every time in this bill where you hear a reference to hate crime or to a reference to hate, you have to, the types of harms, the context of this word being used is inclusive of social, economic and psychological harms.
Yep. So that sort of sets up, we already know this is going to be broad. This is a broadening of the scope rather than a limiting of the scope.
That's right.
And they've chosen to broaden it rather than limit it, which they could have done.
Yes.
Now, let's go to hate crime. What is a hate crime? Now, the legislation has a number of different definitions of hate crime, which is in and of itself somewhat confusing to me, I've got to say.
Yes.
I want to focus on this particular definition, which is the broadest and the one that's been most commented upon. So again, you can go to the legislation. This is you can see there, page 13, right down here, page 13 of the legislation. And I'm going to go here to this paragraph 5, and you can read it here. I'll read it out. A hate crime is also conduct or the threat of conduct, whether engaged in or threatened before or after this section commences. Now, let's just pause there. What does that mean? Before or after this section commences? So does that mean this applies to anything that happened in history?
It's exactly. I mean, that's exactly what it is. This is what we call a retrospective provision.
Right.
It's a gross violation of ordinary rule of law principles, which is you ought not to be convicted or punished for acts in the past which were not at the time unlawful. And what this is saying is, although actually we're putting down the markers now to say that any kind of conduct that we think fits the definition of hate crime at any time in the past will also be captured by this law.
So that'd be like if you know, say you're driving down a road and it used to be 80 kilometres an hour and you were driving at 80 kilometres an hour.
Yep.
And then they change it to 60 kilometres an hour and they say anybody who was found to have been travelling at 80 kilometres an hour in the past is now going to be found to have been in breach of travelling 60 kilometres an hour.
Yeah, no, that's exactly.
So you work because
that's the principle.
Yeah.
That's why such a provision like that is so gross.
Yeah.
And so unusual.
Yeah.
So yeah.
So that's not even getting like on that basis alone. These laws should be opposed.
Yes.
You just should not have retrospective laws because it's Orwellian to say you broke the law 5 years ago, but 5 years ago you were following the law.
Yes.
But now we've changed the law, so we're saying 5 years ago you broke the law.
Yeah. Yeah, and this is
so how could you have avoided it?
And this is like there's centuries of English legal tradition which goes into this principle that
Back to the good old Magna Carta.
You know, exactly right. You know, you have to be punished by laws that actually exist. You know,
this is nuts. This is just. I mean, we've been going through this for a couple of weeks, and the more I dig into this, it's just absolutely nuts what this stuff is, and we're not even in the meat of it yet.
Yeah.
So let's go. What is a hate crime? A hate crime is conduct or the threat of conduct. Okay, what does threat mean? Now, there's some stuff in here which is completely unobjectionable and is already unlawful, causing serious harm to a person, causing serious damage to property, causing a person's, so killing, a death, murdering someone.
Yeah.
It's already unlawful, endangering a person's life, creating, now, this one here is the problem, creating a serious risk to the health or safety of a section of the public, and it has to be done on the basis of a person's race or ethnic origin. So basically you're picking on somebody because of their race or their ethnic origin. So none of this up here, none of this here is objectionable, okay, but it's already unlawful to do this anyway. Yeah. And then they slip this in, creating a serious risk to the health or safety of a section of the public. Now, what's your, I mean, you've got a legal background. I'm asking you, I read that and go, well, that could pretty much mean anything because as you rightly say at the start, they talk about emotional and psychological and economic. Is that what it means?
Well, I mean, yeah. What is the health? Is this, you know, I'm sure during COVID, you know, going outdoors without a mask on was probably deemed by someone in officialdom of being a serious harm to the public health.
Yes.
You know how broad, you know, can you really push that? Well, I think you can push it pretty far.
Yeah.
Yeah. And you're probably about to get there, but you mentioned how it has to be engaged in because of a person's race or ethnic background. But interestingly, in paragraph 6, it says that, well, it's actually immaterial whether the targeted person...
This one here?
Yeah. It's immaterial whether the targeted person was actually distinguished by their race, national or ethnic origin. So it actually doesn't matter who the target is.
Why do they have that in there?
Yeah.
What's the deal with that?
Exactly. And I mean, that just goes to the whole incoherence in so much of this bill and how circular so much of it is.
So if you're out there thinking, this is nuts, you're right.
Yeah.
I mean, you're not wrong.
Yeah.
The people telling you it's okay are wrong. Like your brain is
correct,
okay. Like,
correct. No, I mean, and no wonder so many people are skeptical of, you know, politicians and lawmakers when this was rushed through in about less than a week.
Oh no,
days, a matter of days.
The original bill to the passage, it was about a week.
Yeah.
But this actual draft legislation was only about 1 or 2 days.
Yeah. And like, so in that process, you're going to have absolute nonsense go through. But it's the law of the land.
Yeah. Yeah. Now, let's go to, okay, how does a hate group actually get defined?
Yes.
So again, this is the legislation here, section, Schedule 1, Part 4. We're at 114A.4, regulations specifying prohibited hate groups. Now, you know, before the Governor-General makes a prohibited hate group regulation specifying an organisation, so that's basically the final part of the whole thing.
Yep.
The AFP Minister, which is the Home Affairs Minister, in this case at the moment Tony Burke, must be satisfied on reasonable grounds that an organisation has engaged in prepared or planned to engage in or assisted in the engagement, conducting, constituting a hate crime, which we've just discussed,
Yep.
Or has advocated, whether or not in Australia, which is very interesting about the international reach of this law,
Yes.
engaging in conduct constituting a hate crime.
So that would be something like if there was a hate crime, quote unquote, that occurred overseas and you in Australia commented positively on it, that would be the sort of thing that might
So if you were
fall
skeptical
within
of
that scope.
If you were sort of commenting upon the ICE raids that are taking place in
Yes.
the US,
Yeah, correct. Yeah.
which some groups are aggrieved by,
Yeah.
then that could...
That's right. Yeah. Oh, okay. So you're advocating for that sort of activity? Then
Yes.
Then that's a hate crime.
But you have to be a group, not as an individual.
Yes.
So,
Yes.
Now, so the point here is so this is the Home Affairs Minister, just has to be satisfied, right? So read these words carefully. Satisfied on reasonable grounds. Satisfied means nothing.
No, not really.
You can have any grounds to be satisfied.
Yeah.
Now, the grounds here have to be reasonable, but how would you read that as a legal professional?
I mean, I find that the language is completely empty because the test of whether the minister is satisfied is really in reference to whether the minister was satisfied. It's completely circular. There was actually...
I'm satisfied because I'm satisfied.
Well, exactly. I mean,
It's like
there's no objective test.
It's the opposite of Mick Jagger.
Yeah. So, and there was case law during the pandemic when ministers or public health officials would make public health orders.
That's right.
And because they often had to be satisfied that it was necessary to protect public health. And when they were challenged in court, judges would make reference to, well, they were
Satisfied.
that they were satisfied that it was necessary. And so that's really, and reasonable grounds. Well, no, because they're satisfied. That's the test, whether they were satisfied. Yeah, because they're not going to be satisfied on unreasonable grounds.
Yes.
No minister's going to say, well, I was satisfied even though it was unreasonable.
So
of course they're going to be satisfied that it's reasonable.
What is really interesting about this is those of us who are concerned about the COVID era, and for many reasons, but one of them is we said it sets a precedent. This is basically the application of those vague COVID era standards into our current time.
Yeah, I thought, as I read through this legislation, I do get a lot of almost deja vu
vibes.
from that era. Yeah, from those emergency laws that were passed at the time. Yeah.
Well, these laws were probably drafted in that time.
Well, that's.
I
I mean, yeah. This.
I don't think they just drafted this in 24 hours.
I mean, exactly. I mean, and you have to remember that the initial legislative package was almost 150 pages.
Yeah.
You know, that didn't just. They didn't just draft
yeah.
that. You know, so. You know, I've heard reference to the fact that, this has probably been sitting in someone's drawer
I think I've
for a
made that
while,
reference.
and you might have made that reference.
Yeah, but that is definitely the case.
Yeah.
Well, almost certainly the case.
Yeah.
Now, this is still the part about how, so just have a look at this here. This is still the part about how a hate group is adjudicated by the minister. Now, it explicitly, read this here, it explicitly says this: a conviction is not required. A person does not need to have been convicted of a hate crime. It literally says this in the legislation. So you don't even have to have committed a hate crime for the minister to say that you've committed a hate crime.
Yeah.
And then this part here explicitly says, no procedural fairness required. The AFP minister, which is the Home Affairs minister, is not required to observe any requirements of procedural fairness. It is literally your rights have been written away explicitly in the law.
Yeah, I mean, this is absurd. And so what you're actually getting is the minister is effectively by declaration declaring groups to be criminals.
Yes.
So that's what that provision says. And so it makes that provision on no procedural fairness required even worse, because it means that the targeted group is not afforded, the right to legal representation or a hearing or to present their own evidence. Effectively, they don't have to be consulted. They don't even get the courtesy of a notice that this is happening.
It's just done.
Yeah, it's just done. Yeah.
Now, what the apologists, particularly in the Liberal Party, would point to is, well, it's all okay because of Section 114A.5, the Director General of Security which is of ASIO, the advice must be provided before specifying an organisation as a hate group. So they say, oh, it's okay. Look, this stuff about the Home Affairs Minister isn't great, but we've put a handbrake on it, a safeguard through this provision. But let's actually read this.
Yes.
Is this really a safeguard? So let's look at this. The Director General may provide written advice to the AFP Minister recommending that the AFP Minister consider whether an organisation should be specified as a hate group. However, the Director General may provide the advice only if the Director General is satisfied one of the following have occurred. And that's A and B, so it's confusing because there's one or more, then it says both. But this is for one of the following of A or B. A, both of these have applied. The organisation has engaged in activities, which I assume mean hate activities. And let's just go back up here. The Director General is satisfied that the activities or the continued engagement in the activities would or are likely to increase the risk of politically motivated violence or the promotion of communal violence. Now, let's just pause here for a minute. The Director General of Security of ASIO is appointed by the government. So this is not a safeguard. Because for something to be a safeguard, it has to be independent of the executive government. At a minimum. So whatever you think about the current...
So when you talk about safeguards, you're talking about things like the courts.
Yes.
Because they're completely independent of the government of the day.
Yeah, or even or the Senate. Yeah. Or something that's
separate
to the government.
In a separate institutional barrier.
Yes.
Yeah. An appointee of the government of the day is not independent.
Correct. Yeah. And then, so check this out here. This is the really chilling thing. So I just want to focus on this for a minute. So the Director General is satisfied. So again, we just talked about that's the low bar. So he can just say, yeah, I'm satisfied. Now, read these words very carefully because this is legislation. So this is not an opinion piece published in a newspaper. This is not someone writing something on Twitter. This is black letter LAW law. So we have to read these words carefully and interpret what they actually mean. So the Director General is satisfied that the activities or the continued engagement in the activities, now this is the key part, would or are likely to increase the risk of politically motivated violence or the promotion of communal violence. So let's focus on this. Likely to increase the risk. Well, what does that mean?
Yes.
The risk could be negligible, but I think it's likely to increase from 0% to 0.1%.
Yeah,
so that's an increase.
It doesn't even qualify it by saying a substantial increase or a significant increase. It could be, as you say, a minuscule increase. And I mean, likely to increase the risk. That is a very subjective determination.
I mean, in a democracy, what isn't likely to increase the risk when you have debate? Because the key thing here is increase the risk of politically motivated violence. So again, what a lot of the Liberals would say is, well, that means that we don't want groups that are deliberately designed, like bikie gangs. You're designed to basically break the law. Now, that's not what this says, though. This says increase the risk of violence. So all that means is you're a part of a group that could, because of your views, sort of get other people excited.
Yes.
And then they are the ones that are committing violence.
Yes.
But
you are the prohibited hate group.
Yeah, you're the prohibited hate group because in the absence of your existence, they wouldn't have been provoked. Yes. So it's victim blaming.
Yes.
What I've said before is it's like when a Conservative has an event and protesters come and the police say, well, this is dangerous, so we need to protect the event, so you're going to get the bill. Yeah. So no, hang on, it's the protesters who are causing the violence, not the people at the event. So you could have, let's just think about what this could mean. You could be a group that is formed to communicate the problems of mass migration in Australia, and maybe you hold an event somewhere, but then that elicits protests, and those protests become violent. So the ASIO director says, well, hang on. All he has to do here is say, I'm satisfied that if this event goes ahead, this is likely to increase the risk of politically motivated violence. Therefore, I believe I'm satisfied that you're a hate group. And the minister goes, yeah, well, you're a conservative organisation. I don't like you. Here's my excuse. Off you go. And guess what?
That's it. I mean,
what can you do?
You've pretty much satisfied all the grounds that need to be filled in order to make that declaration.
And here it is again. No procedural fairness. Just to jam it home, Not even the Director General, who's a government appointed public servant, is not required to observe any requirements of procedural fairness.
Yep.
Nor does he actually have to provide any public documentation of how he reached his opinion.
No, at least
It's just madness.
Yeah.
Oh, but hang on, Morgan. It's okay. Section 114A.6, engaging with the Attorney General and Leader of the Opposition. So this is another one of the so-called safeguards.
Hallelujah.
Before the Governor-General makes the prohibited hate group regulation specifying an organisation, the Minister must obtain the Attorney General's agreement in writing to the organisation being specified for the purposes of that definition. So what does that mean? It just means that
a fellow minister of the government
agrees.
will agree.
Yeah. So the Attorney General...
So this is the Home Affairs Minister talking to the Attorney General.
Who's a government minister.
And they're both members of the same government.
So, okay, so that's not really a safeguard. And this is my favourite, arrange for the Leader of the Opposition in the House of Representatives, so in this case it's Susan Lee, to be briefed in relation to that's what it says, briefed.
I know.
What does that mean? All they have to do is walk past and go, hey, I'm banning this group.
Yeah. And how useless is that? I mean, the declaration to prohibit a group will be published on the government registry when it happens anyway. So what? The Leader of the Opposition will find out a few days early?
Yep. If that, yeah. And the only other safeguard here is there's two others. So this is one other I'll get to. The Parliamentary Joint Committee on Intelligence and Security may review the legislative instrument. So when it says legislative instrument, that means basically the lifting of the hate group.
Yep.
And report the committee's comments and recommendations to each House of Parliament. So that means nothing. It's just a review.
Yep.
That may or may not happen.
Yeah. It's an option essentially for the committee to review it.
Yep. Now the only actual semi-safeguard here is the review of disallowable legislative instrument, and there's an extension of the disallowance period. So this is a little bit of a, I guess, technical thing in a way, which is that there are provisions in certain legislation where Parliament can disallow a legislative instrument that's been made by a minister.
So the general rule is that within 15 days of a declaration being created, either House of Parliament can pass a resolution to essentially disallow it.
Yeah.
So I mean, this is an important parliamentary safeguard against potential abuses of executive power. Now that's either House of Parliament can do that.
Yep.
Obviously, in the House of Representatives, that's unlikely to happen because essentially that would be a vote of no confidence in the government, effectively. So that wouldn't happen when they have the numbers. And so, as you said, potentially there's a safeguard here in the Senate. But it's important to remember that this right for the Senate to disallow a ministerial declaration is only, the windows are limited to 15 days. And this legislation extends it by up to 8 days. Okay. So you're talking about 3 weeks afterwards. And then that right ceases to exist.
The only hope you've got is if you do get listed, the Senate says we're going to override it.
And they do it quickly.
Yeah. Yep. So that's better than nothing.
But
that's it.
Yeah, that's it. That is, in this whole legislation, that's the one safeguard.
And there's various penalties. Providing support to so I'm looking at 114B.6, providing support to a hate group, 15 years jail. The person intentionally provides an organisation support, 10 years in jail. So this is hefty stuff, right?
Yeah.
You're not talking about, a slap on the wrist. Or what you're talking about, you're going to jail for a long time.
And like recruiting for a prohibited hate group. So what, handing out membership flyers?
Who knows?
Would be 15 years imprisonment.
This is wild.
Yeah.
Now, I've done this before. If you do a control F of hits put, how do you spell hits put to here? Hit.
Yeah.
Let's do hits. Nothing in there. There is something in here about Nazis in terms of the salute, I think.
Yes,
they make reference
to hate symbols.
And the salute, I think, is in there. Yes. Nazi salute, which is already an offence in parts of the country. But no actual neo-Nazi group is listed.
No.
And his put to here is not listed either.
No.
What you will have heard is a range of MPs, Liberal MPs, defending their support of this bill on the basis that we voted to ban his put to here and neo-Nazis.
Yep.
That is not true.
That's right.
This legislation has not banned any group in particular. as we've just outlined, it gives powers to the Home Affairs Minister to ban those groups in conjunction with the Director General of ASIO.
Yep.
Now, maybe the Home Affairs Minister will ban his put to here. Maybe he will ban neo-Nazi groups. Maybe he won't. But he can also ban any other number of groups, including Jewish organisations, including civil society organisations, potentially including political parties. There is, and this is a key point, the legislation has no limit to the kinds of groups that can be banned if those groups are found to have been engaging in the hate crime activities that we've described.
Yes. Which is described and defined very broadly.
Yeah.
Yeah.
In the context of psychological, emotional, economic harm.
Exactly.
There's no limit to this.
Exactly. And as far as I'm aware, those groups still haven't been banned by the minister.
Well, we're talking right now. I can tell you, we're talking on the 4th of February at 2:24 p.m.
Yep.
They haven't been banned. Now, maybe by the time we put this up, they're banned.
Yep.
Great.
Yes.
Great. Good. I'll be the first in line to shake Tony Burke's hand and say that's good. But as we talk right now, they haven't been banned. And so just every single facet of this is wrong. So anyway, we don't need to keep labouring the point, but what I wanted to do, and thank you for taking your time to do this, is to just actually go through the legislation, because people, regular people know this is bad. A lot of people are intimidated by legal words and legislation. It's not, all you have to do is go through it. I just wanted to talk people through these key sections. And basically, it's if you think this is bad, you're right.
Yes.
Don't let politicians and other intellectuals bully you into thinking that you're wrong. No, you're right.
Or gaslight you into thinking that this was the best possible outcome.
Yeah.
Or something.
And I said this is diabolically bad. It really is diabolically bad. And maybe the government won't take advantage of the laws. Maybe we won't, and who knows? Maybe we'll be okay.
But that power will always, as the law is written,
on the books.
That power is available to them.
Yep.
So that's this is the sort of Damocles hanging over Australians forever.
Yeah, and it does nothing about Bondi.
No.
It'll do nothing. It's got nothing about anti-Semitism. There's a couple of little references to anti-Semitism
in some notes.
They've just whacked it in there. Oh, we better put the word anti-Semitism in there.
Yeah,
that's.
It's in the title of the law, but the actual substance of the bill is
how many times is anti-Semitism actually referenced? There's a few references to anti-Semitism. Most of it is previous laws. It's 17 references to anti-Semitism. How many actual? 13 references to it. How many of them are substantive? So they do reference, necessary and proportionate to address anti-Semitism and so forth. But it's not going to do anything to actually address the foundations of this at all. So. Anyway, let's leave it there. Thank you very much, Morgan, for taking your time to talk us through this. And look, let's hope that these terrible laws are repealed one day.
Yep.